So thank you. So Justice Powell, let me bring you into this conversation if I could. Justice Lemons has talked about the role of the courts, and Justice Mims did as well. You are a member of the court who has served at all levels of the judiciary in Virginia. I was wondering if you could talk a little bit about what you see as the role of the court in our society.
I think the role is exactly as Bill and Don have described it. We are to interpret the laws. We obviously recognize that we don't write them, but sometimes when they are unclear, our interpretation of them to some may be viewed as writing. But we recognize that we interpret the law as the legislature has drafted it, and that has always been our role and will always be the role of the judiciary, not to exceed those bounds, but to certainly operate within those bounds to answer the questions that come before us.
Justice Powell, you wanted to chime in.
Two things. I think here in Virginia, because most of the cases that impact the people of Virginia are heard in General District Court. And so most of them have no real appreciation or understanding or desire to understand what happens here at the Supreme Court level, because most of their issues will never reach us. And so to the extent that there is some education that needs to take place, it's probably there in the trenches at the General District Court level. One of the issues that is particularly interesting to me is the lack of knowledge in our high schools and middle schools. And I think it goes back to what Chief Justice Kenser said: if you teach the children, then you don't have to teach the adults. And so one of the programs that we engage in is a rule of law program where we try and interest the students in what the rule of law is about and try and teach them that the law impacts all of us, and to some extent, because I think in some communities there is a distrust of this body and everybody below us, every court below us, and to the extent that we can better educate, we can disabuse the notions of mistrust.
So at what point then, as you're reading, are you typically persuaded, or at least are you starting to form your thinking around the case? So maybe Justice Powell, I could ask you to start on this. So you start with the appellant's brief, and at what point in the brief do you start to think, okay, I know what this case is about, I'm starting to get this? Is it by the statement of facts?
Is it that I know what the case is about, or I know what the answer is? Which question?
Well, I'll leave it to you to answer that. Let's tend more towards the latter, actually. You're starting to form your view on the case.
It's an evolving process, actually. If I have a well-written appellant's brief, unfortunately, at the end of it, I've decided, yeah, you win. Then I pick up the appellee's brief and I read that, and at the end of that, I thought, oh no, they no longer win. The appellee wins. And then I get to the reply brief, and so it is an evolving process where I am considering the arguments that are made and very persuasive arguments from the two parties. Rarely after I've read everything do I have the answer. I usually wait until oral argument. Sometimes I'll talk with colleagues about it. Certainly the opinion conference has an impact on what the final decision, as far as I'm concerned, will be. And it may even go as far as the draft opinion that comes out before I can finally say I'm comfortable with this position. Usually it's very late in the process for me before I finally settle on a position.
Justice Powell, maybe I could ask you to comment on this as well. So what do you see as sort of the value or the role of a dissenting opinion? And do you think there's more freedom for the justice who's authoring a dissenting opinion? Do you feel like the dissenting opinion should respond maybe more directly to the majority opinion? How do you approach that?
I think the dissenting opinion often will respond more directly to the majority opinion. You don't see that working in the reverse. And I think that's more a culture of the court and to some extent that degree of respect for the majority opinion. But you will often see the dissent responding, I think, to certain aspects of the majority opinion. And I think most often that's when the dissenter really has a strongly held belief that there is something analytically wrong with the majority opinion, and we want to get that view out there. I think sometimes it might, if I'm the dissenting writer, it may be writing for the development of the law. This is where the law is now, not necessarily telegraphing where it should go, but perhaps some instances of, yes, this is where we are, but perhaps this is where we should be. Personally, I sometimes will write for the benefit of the litigants who've brought their case all the way to this court, for that circuit court judge who had a differing view. If I feel strongly enough about their position, then I will write to not necessarily vindicate their position, but at least to say, you were heard. I think that comes from the fact that as a circuit court judge, I had a 7-0 reversal, and I thought certainly somebody on the court saw it my way. So a little nod to the circuit court judges out there that you weren't totally off in left field all by yourself. But I have to feel fairly strongly about it. I'm not just going to do that to appease the circuit court judge.
But you do need, it raises a wonderful point, you do need, when you're writing an opinion, whether it's dissenting or majority, to speak to a variety of audiences. You're speaking, as you said, to the litigants in the case, you're speaking to counsel, you're speaking to the lower court judge in a particular case on appeal, you're speaking to future trial court judges who are going to have to interpret. Maybe in a dissent you're helping to shape the law or suggest the direction of the law. So how do you address all of those audiences in one piece of writing? Do you have to choose which audience you're going to emphasize? Do you try to address all of those audiences?
I think I'm more addressing the issue, and the issue will then speak to the audience. I'm addressing the issue with which I disagree, not necessarily targeting an audience so much as targeting an issue.
Good. So we spent some time talking about oral argument and how it affects or can affect the way in which you think about a case. So Justice Powell, I was wondering if you could talk a little bit about how you prepare for oral argument. Do you come in with a list of questions that you hope to ask? Do you sort of see how the conversation goes? Do you have particular questions or issues that you want to try to see get resolved, whether you're asking the question or one of your colleagues is? How do you start to think about oral argument when that day arrives?
Generally, I will come into oral argument with some questions that I want answered. I'll have them written down in my book and scripted out so that I can ask them intelligently before the cameras. And half the time I don't get to them, or the flow of the argument will turn me in an entirely different direction. And so a lot depends on how the argument is going, what questions my colleagues may be asking, something that they may say that I hadn't focused on in the brief from the litigants. And so I will come in with questions. I don't always get them answered, or they may become irrelevant depending on how the conversation is flowing.
And what kinds of questions are you typically looking for at that point, or trying to get answered?
The answer to the question. The answer to the case.
But,
who wins, who loses.
But are they questions that the briefs didn't answer sufficiently? Are there typically questions that you think they didn't address?
They're generally questions that the brief raises. They may have an answer, but my question might be a what if. My question might be, the appellee argues X and you've argued Y, and I don't see that either answer is sufficient for my purposes. And so I may ask both litigants to answer the same question, but they're generally questions that is slightly different from the argument that was made.
Testing the boundaries of the argument,
yes.
For example. You can think about the implications of what that argument might be. So along those lines, Justice Powell, when appellee gets up to give his or her oral argument, thinking like a judge, should he or she proceed with his or her own argument, or respond to the points or the questions that were just made during appellant's argument? What do you think is the right course of action then?
As I'm listening to my colleagues, and I was anticipating that question, was that on a sheet? I think probably first respond to the issues that we're obviously having difficulty with based on the questions that we ask the appellant. certainly leaving time to address the issues that they came in wanting to tell us about. But I think they're going to be able to tell, or if they're listening, they should be able to tell what's bothering the various justices, what positions they need to develop in order to bring a justice over to their side or bring them away from the other side. And so I think probably the most effective approach would be to answer the questions that are being asked, even of the other side, in the way that best reflects their case.
So let's talk a bit about previous career experience. So Justice Powell, you've had a variety of experiences before you took the bench. In-house counsel, executive branch, private practice, service on each of the lower courts. How do you think that's influenced your work here on the court?
Certainly the prior trial court experience has been very helpful if I'm looking at a transcript and I can visualize myself in that courtroom and pretty much tell what chaos was breaking out when objections weren't preserved or statements were made. So I think that experience gives me a deeper appreciation for the trial record and what's going on in the trial court. My experience on the General District Court gives me tremendous empathy and not empathy and a sense of appreciation of the issues that finally wind their way to us and how they're going to impact all of the issues that we will, or the cases, individual cases, that we will never see. The time in the Attorney General's office, tremendous time management skills, time in private practice, sitting at counsel tables, second, third, fourth chair, learning cases from the inside out. And so all of the prior experience, I think, has brought me to this time and place in various and different ways.
Are there things you miss about your life before you took the bench?
I miss the live, in the moment of the trial court. I balance that against the contemplative, being able to think it through of the appellate court. And so there are positives and minuses to both, but I do miss the live in the moment.
Was the sort of contemplative part surprising to you?
No. Okay. I've always, as a trial court judge, I wanted to be able to discuss the case with someone who heard the same case that I heard, as opposed to hearing it through my lens. And so I have that here. And so that aspect of trial court I get here. The live and the being able to decide it on my own without having to worry about what these other guys and gals think.
You miss a little autonomy.
I do miss a little autonomy.
Justice Powell, so you've joined the court relatively recently in comparison to your colleagues. So what do you find are sort of the frustrations or the things that maybe were new to you?
Could not have said it better, the time constraint. I would like to have the opportunity to write the opinion, send it out, sit around the table with them one more time and discuss every page and every line, put it on the shelf, make sure that it's right before we pull the trigger. And what's frustrating is that we don't have the luxury of all of that time. And I don't know if it would be a better product. Perhaps some of my colleagues have had the benefit of all the time they needed and decided the product that they sent out was the best product. But it's the crush of the time and the amount of the work and the need to keep the train moving and the desire.
The perfect being the enemy of the good, though, otherwise.
And the desire to get it as right as we can get it and the amount of time that we have to devote to it. So it's a little frustrating.
Yeah.